Welcome back to Real Clear Radio Hour, brought to you by the Competitive Enterprise Institute. I'm your host, Bill Frezza. We're pleased to welcome Carrie Severino, Chief Counsel and Policy Director for the Judicial Crisis Network, to help us dig into the recently completed oral arguments in the King v. Burwell Obamacare case. Carrie's a former clerk for Supreme Court Justice Clarence Thomas and an activist constitutional scholar. Carrie, welcome to the show.
Hi, thanks for having me.
Carrie, I'm neither a lawyer nor a Supreme Court camp follower, but I did read the transcript of the oral arguments, King versus Burwell, and it reminded me of a bunch of fourth graders on the playground arguing about whether Sally was tagged out. Does the fate of the Republic really hang on these oral arguments, or is this just theater with the real action going on behind the scenes?
Well, yes and no. There are real issues being dealt with in oral arguments, but honestly, the vast, vast majority of what's going on happens before the argument itself, because there are thousands of pages of briefing that are done behind the scenes that the judges will have received or earlier. They'll have read them. There they've got all of the legal nitty-gritty, the cites to all sorts of laws. There's dozens of briefs that have been filed by friends of the court, amici on both sides, saying why there are other groups besides just the government and the plaintiffs in the case who have interests in this and making their own variations on the arguments. And that's really where the justices make a lot of their decisions. I think it's very rare, at least from my experience, and I clerked in the court for a few years ago now, and I suspect there are very few cases where what happens during oral argument really is going to change someone's mind dramatically, because they've thought through this all in such detail before the arguments take place.
So what's the point?
It's a chance for them to really kind of test out and hone some of their arguments, especially with the back and forth.
Is there a larger PR purpose in doing this as well, to sort of warm up the American public to where they might be heading?
You know, the oral argument system way predates our common notion of PR now, and if there's anything the court wants to do, it's to avoid that notion. So, well, it's turned into that in some ways, and this is why you have the media pushing for, let's have more cameras in the courtroom, et cetera. The court really has done everything it can to push back on that, because they don't want it to turn into a media circus. If you go outside the court the day of the arguments, it is a media circus nowadays. Yeah. It's gotten more and more that way over the past decade or so, where there'll people be chanting and shouting, but that's not what the justices are looking at, and that's not what we want them to look at. Yeah. We want them to be doling out equal justice under law, not counting how many protesters are on each side and figuring out which ones they sympathize with the most. No, look at the law, tell us what the law says, and that's their job.
Wouldn't that be nice? So let's spend our time sort of digging into how the Supreme Court sausage is made a little bit and run through some of the things that my eye picked up in the transcript. Right at the beginning, it looked like Justice Ginsburg took a run at trying to show that some of the plaintiffs lacked standing, and the attorney for the government tried to grab a hold of that on the fly. What was that all about?
Yeah, now just for a background, standing is a constitutional requirement. That means that people who bring cases before the court, there has to be a real case or controversy. And so you can't just bring a case saying, I don't like this, how this law is being implemented or whatever. You have to actually be personally hurt by it. And what's interesting there is that Justice Ginsburg was getting those arguments not from the briefs, not from the parties, but actually from a lot of stuff that was going on in the media. Yeah, there was a big push about the Mother Jones article that was kind of almost ad hominem, digging up stuff about the petitioners in the case, who are the people who are challenging the IRS regulation, saying, well, they could have gotten health care. A couple of them are veterans, and a couple of them, we think they're not going to make enough money this year. They could probably qualify to be below the limit and not be subject to the individual mandate anyway. And so how can they even bring the case? And this was just sort of an outside journalist digging around. Well, Justice Ginsburg decided to bring that into oral arguments, and I was actually a little surprised that she even interrupted the first sentence of Mike Carvin, the lawyer for the petitioner, to go there. But I think it's clear that the court is not going to take up that line of reasoning. The Chief Justice, who really those standing arguments were largely aimed at, thinking, oh, this is a good way to just get the case off of his lap, and he maybe doesn't want to decide the issue anyway. He clearly signaled later in the argument he doesn't want to go there. And besides which, as long as at least one of the petitioners has standing, the court will hear the case. As long as at least one of them, you don't have to prove that every single one of them, go into all of the details of their financial lives. And it looks very clear that this has really just been kind of an attack effort trying to get rid of this case. I think because there were a lot of people very nervous that the court may overturn the IRS regulation.
Doesn't this show that the court does respond to the howling of the mob?
Unfortunately, it does. And it's not really the first time that some of this stuff has been brought up. At the last Obamacare case, Justice Sotomayor brought in some arguments that were largely made based on a few legal blogs and it kind of tried those waters for those arguments at oral arguments. So it does happen. They're human beings like we are. I think we just have to hope that they are doing all they can not to be influenced. And to the extent that there are legal arguments being made out there, it's not the appropriate venue. You should be doing this in a brief if you're making legal arguments. But at least if it's a legal argument, it's one thing. The really inappropriate type of lobbying, which we saw a lot of in this case, is the lobbying saying things like, Chief Justice Roberts, it's going to be your fault if Obamacare goes down, talking about these pronouncements of gloom and doom and the sky is going to fall if you go the other way on this case, or we're all going to talk about how the court has lost its legitimacy if you don't rule the way that we think in this case. Those are sort of media terrorism. We're going to all give you a bad name if you don't rule the right way, and that's absolutely inappropriate for the justices to be considering in any way.
Without getting too wonky, when I look at this, it doesn't seem to be an issue of the constitutionality of the law, but an issue of statutory construction. Can you tell us what that means? Yeah,
that's an important distinction, because the last case that the court heard on Obamacare was a constitutional question. It had to do with whether they could even make a law that had an individual mandate in it, because Congress doesn't have the power to just straight up command people to do things in any area. There's certain areas that the federal government has authority, and the rest, all it should be reserved to the states. So the question really was, can they do Obamacare in this way at all in the last case? Because if the Constitution forbids it, that's it. In this case, not so. Really, it's the text of the law that's the issue for the government, because the text of the law is pretty clear and says you only get subsidies, exchanges established by a state. And they would like the subsidies to be available at other exchanges, given the fact that most states have not established exchanges. So they really just want to change the text of the law. That's something Congress could have easily done. They had drafts of the law that didn't have this kind of text in it, and they didn't choose those drafts. So it's easily within the power of Congress. Congress could go back and change that tomorrow if they wanted to. I don't think they will, given the fact that powers have switched around in Congress since the passage of Obamacare, probably because of the passage of Obamacare. But it is something that's totally within the power of the legislature to fix. And the court, when it's doing statutory interpretation like that, is a much less high stakes. They realize that, even if we interpret this law
fix it
differently than Congress would have liked us to, they have an easy recourse. They can just go back and rewrite it, and that they do that with some regularity. You can think of a few years ago, there was an employment discrimination case, and out of that, they came up with the Lilly Ledbetter law that changed the statute of limitations on employer discrimination claims because they didn't like how the Supreme Court decided it. That's fine. That's Congress's prerogative. If it's a constitutional issue, the court is much more final because the likelihood of passing a constitutional amendment to change something is pretty low. So I think it means the stakes are not nearly as high as in the previous case.
What is the Supreme Court's actual job if Congress passes a law that's silly, ill-conceived, or self-contradictory?
Right. The court's job is to interpret the laws and just apply them as Congress wrote them. Our constitutional
even if they're
system,
silly.
You know what? We have a representative government, so that if we have a Congress passing silly laws and a president willing to sign silly laws, that's our own fault. And so if people then realize, hey, these laws are ridiculous, I don't want to have these laws, you have a great option. You vote the president out of office, you vote the Congress out of office, and then get the laws changed.
But it's not the Supreme Court's job to fix that.
And no, that's not the court's job. They're unelected. Their job is simply to tell us what the law says. And so it's supposed to be neutral.
That seems to be where Scalia spent most of the time in his conversation, is really focusing on that element of, it's not my job to fix it if it's broken. We're just trying to figure out what the words mean.
Yeah, and that's really the truth, because otherwise you have essentially politicians in robes. You don't want people up there saying, well, this doesn't make any sense how they did this, or I wouldn't do it this way. There's a lot of things. I mean, I think Republicans in Congress were saying the whole time, this isn't going to make health care affordable. This isn't going to work as you're saying. So the argument that if this doesn't work as Congress intended it, someone else should step in and fix it, that just doesn't fly. There were a lot of people who thought, even as described, these policies aren't going to work. And in fact, in many ways, we've seen that play out, that it hasn't worked entirely as intended. But that's not the court's role to fix. That's Congress, and they can certainly go back and do so.
So, Carrie, reading the transcript of the oral arguments in King versus Burwell, the government's main argument seems to be that Congress intended to produce goodness, health care for everyone. And so any Supreme Court ruling that does not result in goodness goes against Congress's intent. Did I understand that right?
Well, it does almost boil down to that sometimes. People will say there were articles written saying things like, look, they're talking about making health care affordable. It's the Affordable Care Act, after all.
That's what it says.
How could they intend something that would so clearly make it unaffordable? But that's not also, we don't interpret laws based on their title. And there's a couple principles here. One is, if the text of the language is clear, even if it seems to be the most idiotic language you can imagine, how could this possibly affect the statute the way they want to? If it's absolutely clear, the court doesn't get to second guess what Congress did. That's Congress's job. They should be proofreading their own statutes to make sure they mean what they say. And second of all, it really depends on your interpretation of how this was designed to work, because there actually are a lot of different theories of how this could have worked. And we see some of them that came out as this was progressing from the architects of the law themselves. Someone like Jonathan Gruber, who is an MIT professor, who is widely acknowledged as being one of the top experts on this law. And he said this provision was in there precisely to encourage states to set up exchanges.
Encourage or threaten.
It makes it very high stakes for the states. If they don't set up an exchange, they lose a lot of federal money. And this is a very typical way that the federal government tries to rope states into being involved in federal programs. And frankly, states almost always take the bait. This is one of the rare cases they haven't. So there are a lot of people who said, yeah, it does have disastrous consequences in terms of the amount of money the states would lose, but that's exactly the point. And there are a lot of congressmen now saying, oh, actually, I didn't think that's what it did. That's not how I read the law. But you know what? What congressmen say years after the fact and in the context of charged litigation isn't really what we're looking at. You can't get into the minds of 535 different members of Congress anyway and figure out if they've all understood the law the same way. We have to all just look at the text and say, what is the law? Because no one should be bound by the subjective intent of any one particular congressman. It's really just what is the law that they've passed. That's the best indicator of what they intended to do.
There does seem to be some role that congressional intent plays in the Supreme Court's interpretation, at least the contemporaneous congressional intent when the law was written. Is that being neglected entirely in this case? Well,
intent is really judged first and foremost by the court in terms of what the law says, the text of the law itself, because the judges aren't able to psychoanalyze the members of Congress and figure out what was really in their minds. You often would not have one consistent idea of what the senators and congressmen were intending in the first place. Many of them might be hoping a law will go one way or the other, or might, frankly, in the case of a law like this, they may not have read the whole thing. Nancy Pelosi was suggesting people would have to pass it to find out what was in it.
But could they have looked at earlier drafts and see how the wording evolved?
Oh, sure. And actually, we have alternate drafts that had different wording. One of the challenges is, of course, the election of Scott Brown in the middle of the passage of Obamacare meant that the Democrats didn't have the flexibility to go back and maybe pick a different draft. They were stuck with the one draft they had passed, knowing that they couldn't pass anything else in the Senate, at least, once he was elected. So some people will point to that and say, oh, well, we didn't really mean it this way because we would have gone back and done something different. But you know what? If you pass the law, that's how the law is. You can't go back and say do-over. This is simply the law that was passed, and it's the law that we have. If they weren't happy with the law at the time to fix that was back in 2010, not now.
Some of the oral arguments revolved around an understanding of federalism. And in that context, what does unconstitutionally coercive mean? Justice Kennedy seemed to focus on that.
Right. Justice Kennedy's arguments were interesting because they weren't arguments that were being made by either party. They were federalism arguments made in some of the amicus briefs, but they didn't even generally focus on this coercion issue so much. Coercion is something that came into play in the last Obamacare case, and that had to do with the Medicaid expansion, where the government, technically in the law, it originally said, if you don't expand Medicaid as we would like you to, you're going to lose all of your funding, all of your Medicaid funding. And what the court ended up saying is states are their own sovereigns. The federal government's a sovereign, the state's a sovereign. They've made a deal, at least in certain areas on Medicaid, that if we do this, get involved in this program, you're going to pay us this. It's too great of a coercion to say, now we're going to take all of the money we've been giving you for dozens of years already.
And take it away.
Take it away, exactly, for just not doing this one expansion. However, the court did say it's all right to condition the future money,
new money,
or the additional money they were going to pay for the expansion of Medicaid on the states actually expanding the Medicaid programs. So there were sort of two sides to it. You can condition future money on being involved in a future program. You just can't threaten to take away all their past money when it's something of that magnitude.
So where was Justice Kennedy coming from on this?
Well, this is an argument that, again, was played out in more on the sidelines. but that he picked up on, and saying if exchange is established by a state really does mean established by a state, so a lot of these states, 34 states, aren't going to get subsidies under the proper interpretation of the law. Maybe that's such a huge consequence that coerces them to do it. We're dangling so much money in front of them that means that they're being forced to do it. So if we interpret the law according to its plain text, it's going to create this other constitutional problem, and that triggers a doctrine called the doctrine of constitutional doubt, the avoidance of constitutional doubt canon. And in that case, the court, if it's got an ambiguous statute, will try to avoid interpreting it so that it creates a major constitutional problem. They'll say, we've got two ways to look at this wording. Let's not do the one that's more problematic constitutionally. Let's do the one that's less problematic. And the challenge here is,
which is less problematic?
Both of them could be wrong. The problem is the law isn't actually ambiguous. I mean, it's pretty clear. Established by a state, the federal government's not a state. So, if you have to already think that the law is ambiguous and that there's a feasible other interpretation to even get into that canon. It seemed like Justice Kennedy might be pushing that harder than really there's a lot of case precedent to support. On top of which, the type of coercion he's talking about, coercion by dangling money in front of you, isn't what the court has really found coercive before. This is not coercion by taking away money you already had. This is coercion by dangling money and saying you don't get it if you don't set up an exchange. That's exactly what they said was okay in NFIB, and that would, if he decided to rule that way and the court went that way, I think it actually would be a sea change in coercion law and could be open season on a lot of different types of law. No Child Left Behind has things like that. The Clean Air Act, a lot of environmental laws have things like this where they ask states to set up programs and then offer them tons of money to do so. So this is not unusual. And I think maybe if he goes back and reconsiders it, this is the problem with going into arguments that don't have a lot of briefing on them, because the briefing is really more important and gets into the law. I think if he goes back and looks at it, I'm hopeful that Justice Kennedy wouldn't go down that road, because I think it would open up a Pandora's box of challenging all sorts of federal spending legislation.
Justice Sotomayor tried to make the point that these exchanges make no sense without subsidies because nobody would go into them if there weren't subsidies. Doesn't that get back to the issue of her trying to fix a nonsensical law?
The "it makes no sense" point came up a lot. Why would Congress ever do this? This makes no sense. And so that's the one valid point where intent does come in. And I agree that they're much less useful if you don't have subsidies on them. But there are still a few ways in which they are useful. They were supposed to be a clearinghouse. They were supposed to give you all sorts of good information about the insurance that you don't normally have access to, so you can compare and contrast plans very well. So there is some value. But part of the argument on the other side is, they were intended to cripple their usefulness, because that's exactly the incentive that the law was designed to create for states. If you want to have a useful exchange for your citizens, then you'd better set it up yourself, because otherwise they're going to get a second-rate exchange. And they didn't even know what healthcare.gov, what kind of glitch that was going to turn into. So
sure. Justice Alito seems to be building an off-ramp for one concern. Everybody's worried that if the Supreme Court makes a precipitous decision and everyone's subsidies are taken away, at least in those 36 or 37 states, disaster instantly ensues. And Justice Alito pointed out that maybe they could stay the ruling to the end of the year and give people time to get their affairs in order. Is there a precedent for that?
Frankly, as the Supreme Court, it mostly can do
whatever it wants.
Whatever it wants, because it's the final word, right? But it's definitely possible the court would do that. It would be a little bit unusual in this case only because it would mean the court effectively authorizing the payment of billions of federal dollars that aren't authorized by Congress. And that's questionable in and of itself. The court might view that as a way to soften the blow of taking out these subsidies when people are relying on them. At the same time, I'm not sure it would really be necessary because, as also came up during the arguments and Justice Scalia mentioned, there is going to be incredible political pressure not to let these subsidies go away in the meantime. I think the Republicans in Congress are looking at a lot of short-term and long-term options to fix things. Short-term, to make sure people don't lose subsidies that they were told they were eligible for. In fact, maybe they weren't eligible for, and the court's going to decide. But to extend some kind of availability of either COBRA-type coverage or extend those actual subsidies temporarily, and that will allow Congress some time to work out, hopefully with the assistance of the president, a real option that will be able to be something acceptable to all 50 states, not just a minority of states, something to replace some of the problematic aspects of Obamacare altogether. So I don't think they want to just reenact Obamacare with the subsidies. That's not, frankly, why we have a Republican Congress right now. It's probably because the American people don't want more of the same of this. I think they would rather have a system that works better. And this will be an opportunity for Congress to say, let's all get to the table and hopefully light a fire under the president as well to say we have to actually work together on this, because up until now he's been saying we don't have another solution. We just want to make this as high stakes as possible.
The government attorney made a mocking reference to the current Congress and their ability to fix anything. Is that a good argument to be making?
Well, it practically, politically, it's true. They're not going to want to just rewrite the law as the Democrats would have, but I think that's actually precisely why the political process should be dealing with this. The reason the Congress looks different now than it did when Obamacare was passed is precisely because of the passage of Obamacare. It was incredibly unpopular. This is why we have these huge elections in like 2010, 2014, that moving a lot of those people who voted for it out. And so what the American people seems to want, at least as judged by their voting in these elections, is not a Congress that's going to simply go back and fix Obamacare and make it work as the Democrats would have wanted, but to find an alternative system, maybe a market-based system or one that has more state involvement that will get health care done differently and more efficiently without some of the negative impacts on the economy and on people's health care freedom. So whether or not you think Congress really is going to make a fix, that doesn't mean that it's not still Congress's job. It's not the court's job to step in and say, hey, we don't think Congress is coming up with the answer we want, which apparently in some cases is we want them just to write this subsidy thing the way the government's arguing. That's not the reason that the court should step in and do something different. If Congress thinks that's not the best solution, that's in Congress's court.
Carrie, either way the court rules, what should we expect next?
Well, I think it will be a close case, and if the court rules in favor of upholding these subsidies, then we're just going to see
more of the same.
Billions of dollars of federal subsidies going to these states, possibly contrary to the intent of the law, which is a problem for our constitutional system. But as I hope they hold Congress to the words that they actually passed, I think what we'll see is immediately some interim plans by the government, by the Congress to step in and resort out the healthcare system. I think it'll be a great opportunity to get a system that will work in America, something that can replace some of the failures that we've seen in Obamacare so far. So, and I think it will also help reassure people that in America, under our Constitution, it's still Congress that makes the law. It's not an IRS. It's not politicized agencies. And that will keep our system strong and where it's supposed to be under the Constitution.
Well, Carrie, we'll all be watching this very closely. Thanks for helping us understand it.
Thanks, Bill.
That was Carrie Severino, Chief Counsel and Policy Director for the Judicial Crisis Network, here on Real Clear Radio Hour, brought to you by the Competitive Enterprise Institute. I'm your host, Bill Frezza. Real Clear Radio Hour is produced in conjunction with Real Clear Politics, America's premier independent political website. If you'd like to hear more, stop by realclearradio.org to sign up for updates on our weekly broadcasts or access podcasts of our past programs. That wraps up our show for this week. Join us next week, same time, same station. See you then.